Hey everyone, Harry here to talk about a really interesting wrinkle in Mark Meadows' efforts to get removal and then immunity. So, remember, he's sued in state court. He makes a motion for others have and will, but he does it first day out of the box to have his case be in federal court. We'll talk more about this. It's very important what's going on because he's not looking just to have his case in federal court. He's looking to have his case go away under a ruling of immunity, which he thinks will be much better received in federal court. But first, he's got to get it there. And I think he's betting the house on this. This is his whole strategy. And that's why he decided to take the stand to everyone's surprise. So he testifies 3.5 hours on direct, 1.5 on cross. A lot of what he says makes it sound like just, workaday stuff, whatever the president was doing, even if it's political. My job is to, be around him, streamline things for him, set things up for decisions, steer people away, etc. But there were certain things he did that are much dicier and sound very far-fetched to call like regular chief of staff stuff. And that's where Trump is really doing, clearly illegal solicitation of fraud. The best example here might be the Raffensperger call, right? What is Meadows' excuse there? Okay, so he testifies, and Judge Steve Jones says this is an issue of first impression in some ways, and he'll decide it pretty soon. The parties are supposed to be arraigned back in state court, and he says unless he rules, assume you're still in state court, Mark Meadows, and you'll be arraigned that day, etc. So that's how it stood until Judge Jones issued a request. Request means demand when you're a judge, for briefing. And on a very short turnaround, less than 48 hours. And here's the question. Suppose I find that there is one overt act or more, and remember there are over 100 in the complaint. I think 106 in the indictment. I think 160. That totally is within his regular duties, but not others. In that event, with that one overt act, could that tail wag the dog and be enough to bring the whole case into federal court? So that's a very, significant question. And, if it's not one, what about 5? What about 159, but one clearly isn't? And do the overt acts, so we have, overt acts, just to recap, you guys probably know this, but a conspiracy is you agree to do something unlawful and you do an overt act in furtherance of it. And that could be anything. That could be a phone call, a letter, not something that's illegal in and of itself. There are other things in the complaint that go to, and the state has to prove 2 of them, showing the RICO violation, and those are themselves unlawful. But Jones is talking about all these overt acts. So what does he have to find? That suggests to me, well, first, I think maybe most importantly, suggests to me that he thinks some overt acts plainly don't cut it. And, imagine there's 160 acts, and the last one is to call a hitman to arrange for Biden to be shot. It doesn't matter, it seems, what the other 159 are, right? But let's say the 160. Well, you guys can see the puzzle that Jones is asking the parties to solve for him. And recall, this motion under 1442, which is I'm a federal official and I don't have to stand trial in the state. That motion is itself subject to appeal. So if this really does turn out under Jones's analysis to be, tricky, rich, subject to reasonable differences, you can expect that Meadows will be able, and why wouldn't he do it, to bring it up to the 11th Circuit and even to the Supreme Court. So we're looking at a situation where it seems Jones, the state persuaded him that there's some rotten stuff afoot here. And he's going to want to know, is it enough for Meadows that there's also some benign stuff? Seems like it shouldn't be that just doing some benign stuff gets you a right to be removed. But what's the percentage? What's the breakdown, et cetera? That looks to me like it's going to be a critical and maybe cutting ground issue in the adjudication of the removal motion, which again is just going to be prior to what the real main event is for Meadows if he gets removed, which is to try to establish immunity. That's a whole different legal kettle of fish. We'll go into it if and when it happens. But this one just got richer and more interesting. Point one. And point two is, I think it's clear the judge has found that some of this stuff can't be justified as within Meadows's sort of general official duties. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.